Good afternoon. Welcome to the 1L Convocation lecture series. As you know, this is a series that is organized and coordinated by Dean Iturian and myself. I'm Professor Keith Bybee. The selection of the speakers for this convocation speakers designed to bring distinguished practitioners and faculty to campus for the benefit of the university community, but also for the particular benefit of the College of Law 1L class. Before I introduce our speaker for today, let me just remind you of the protocol. The lecture will go on for about 35 minutes. There'll be an opportunity for Q&A. If you have a question, raise your hand, and we have people with wireless microphones that will come and give you microphones so your question can be heard by other members of the audience and also captured on a recording. I ask that you please make sure that any phones or devices that you have with you are in their off position so we don't have any disturbances during the lecture. Our speaker today is Professor Gerald Torres. He currently holds the Marc and Beth Goldberg Distinguished Visiting Professor of Law position at Cornell Law School. He has been Bryant Smith Chair in Law, University of Texas at Austin School of Law, and just recently decided to join the Cornell faculty permanently. So please join me in welcoming Professor Torres to the neighborhood. Good to have him. The title of his lecture today is Durable Legal Change, Lawyering, Social Movements, and Our Constitutional Tradition. A former president of the Association of American Law Schools, Professor Torres is a leading figure in critical race theory and an expert in agricultural and environmental law. He has served in a number of positions in government. He was Deputy Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Department of Justice, and as counsel to then U.S. Attorney Janet Reno. He is a member of the Council on Foreign Relations and the American Law Institute, and has served on the boards of the Environmental Law Institute and the National Petroleum Council, as well as on the EPA's National Environmental Justice Advisory Council. Professor Torres has won many awards, and among them was the 2004 Legal Service Award from the Mexican-American Legal Defense and Educational Fund for his work to advance the legal rights of Latinos. His latest book was co-authored with Harvard professor Lanning Guinier, is entitled The Miner's Canary, Enlisting Race, Resisting Power, and Transforming Democracy. It's a truly excellent book. Publishers Weekly called it a work that was the most provocative and challenging books on race produced in years. We're truly fortunate to have him with us today. Please join me in welcoming Professor Gerald Torres.
Not that I'll need the water, but need to be careful. First of all, I want to thank all of you for coming today. I'd like to thank the Dean and my friends on the faculty for making this opportunity available to me. I am moving to the neighborhood, so I appreciate the chance to get to know people both here in Syracuse as well as Central New York generally. And I look forward to maybe coming up here more often. There are a number. Offers different opportunities than Ithaca, let's say. Ithaca is a great place, but it's a little small. In any event, I want to thank you. What I want to talk to you today about is actually a part of a project that Professor Guinier and I are working on. We're finishing up another book on legal change. And so I want to talk about how durable legal change is produced and the role that lawyers have in producing that change, and the public nature of the enterprise you're undertaking. One of the things that marks our society, I think in distinction to a lot of societies around the world, democratic societies around the world, is that lawyers have always played an important public role, even when they're serving in private capacities, because law is, in its practice, a public profession. And that public profession then entails a number of responsibilities and a number of roles. And that when you think about legal change, and you think about the role of lawyers in producing legal change, one of the things I want you to think about is, what are the varieties of roles you're going to be playing? The first thing and most important role is that you're going to be playing a technical role for the people you work for and with. And that means, and I tell this to my students, I especially tell it to my students who are interested in doing public interest law, is that the first thing you've got to do is be a good lawyer. Because what you're bringing to the party is a set of skills, and the more skills you have and the better you are at them, the more value you're going to bring. That even if you have political commitments, people aren't hiring you for your political commitments. They're hiring you to be a lawyer. And that is your fundamental and most critical obligation, is to learn to be a good lawyer. Now, of course, learning to be a good lawyer necessarily entails more than just the technical aspects of practice. It also means recognizing that because it is a public profession, that you are bringing to the practice a conception of what you think the good ought to be. And I suspect that all of you, when you came to law school, all of you could have chosen to do something else. You could have chosen to go to business school. You could have chosen to go to work. You could have chosen to go graduate school in one field or another, but you didn't. You chose to come to law school. And you chose to come to law school not just because you want to be lawyers. You chose to come to law school because I suspect all of you have your own conception of what the good or the just is. And that conception is what's going to frame the use to which you put your tools. So how do you produce durable legal change? I want to refer to a fellow named Thomas Stoddard, who was a professor at NYU, and he was actively engaged in the effort to get New York City to pass laws preventing or prohibiting discrimination against gay and lesbian people in employment and otherwise. And he labored extensively, suffering defeat after defeat after defeat. 15 years of bringing it before the city council, of organizing, of having public discussion. He was never able to get it, he and the people he worked with, were never able to get it passed. And so he then decided he'd had enough and he was going to take a vacation. And so he searched the world and he thought, I'm going to choose the place that has the most gay-friendly legal system and legal guarantees, and I'm just going to go there and live life the way it should be lived, at least for a few weeks. And so he chose New Zealand, which has the most gay-friendly legal system. And he flew to New Zealand, and he arrived there expecting a kind of, for him, a gay paradise. And he discovered what he said was New York in 1950. And so he was puzzled. He said, how is it that they had this legal system that seemed to guarantee the kinds of things that he was fighting for so vigorously in New York, but when he arrived in New Zealand, the cultural life was, in fact, significantly behind the life that he could have lived as a gay man in New York City. And so he puzzled about it, and he realized that legal change is just one aspect. That is, rule change. If you think of legal change as merely changing the rules that govern, it is only one aspect of producing social change. And in order to create legal change that actually has an impact in the world, you have to both change the rules, but you also have to change the culture within which those rules are operating. And so he realized that despite the defeats that he'd suffered over 15 years in New York trying to get the rules changed, that those defeats actually served an important purpose. Not that anyone likes losing. I'm sure no one does, at least I don't, and I suspect you don't either. But what it did do is it generated a debate. It generated discussion, so that when the rules were finally changed, the culture had changed as well. And so the rules actually had fertile ground to root in, and in fact, produced the kind of change that he was searching for. I like to think, and see my colleague here, about environmental rules. One of the most important debates we're having now is about climate instability. We have doubters, we have deniers, we have people who say that we can't make the kinds of changes we need to make in order to address the issue of climate instability because the costs are too high. And it feels a lot like losing. It feels a lot like losing, I will say, as an environmentalist. But I have to think that one of the roles that I have to undertake as a lawyer is not just to fight the fight in the legislature and in the courts, and I'll talk to you about another case we're working on that involves more direct advocacy. I have to think that engaging the broader public in the debate about the threats posed by greenhouse gases is actually going to be critical to making the changes we have to make when we finally do get the laws to reflect the risk we're facing. So that I, as a lawyer, then have two tasks. One is to engage the regulatory and legislative systems within which I operate, but also to engage the public about not just the rules that have to change, but what it will mean to the way life is lived. And if I'm successful, why it in fact will make life better. That debate, even though it feels a lot like losing right now, if Professor Stoddard is correct, is actually going to be important for making the changes manifest and making them durable. I'm going to tell you one more story about durable legal change, right? And then I'm going to talk about the atmospheric trust litigation that we're currently engaged in. One of the things that engagement with public debate allows you to do, and remember, part of my talk is our constitutional tradition, is to reframe what the nature of that tradition is. Because courts are not computers. Courts respond both to the arguments that are made, the arguments you all are going to make, but they don't respond just to your arguments, because your arguments have to make sense in the context of the normative structure that the courts are operating, and that means the background values that the culture as a whole accepts. So part of that struggle outside of the courtroom in public advocacy is about changing the background against which decisions will be made. And it's changing the background against which decisions will be made means that the interpretations that courts can make have a broader or narrower ambit. So let me give you an example from the recent past in the civil rights context. I mean, I could choose a number of examples from the civil rights context, but I'll take one case that is, in fact, viewed by most lawyers to be one of, if not the most important case decided in the 20th century. Right? And that's Brown against Board of Education. How many of you have read Brown? Anyone? So now I could call on you and ask you what it means, right? But I'm not gonna. I'm not going to. The reality is Brown's a very short opinion. It's a very brief opinion. When you read it, it's actually relatively cryptic. Because when I ask students, what does Brown stand for, they typically tell me something that is not found in the opinion. And so the question I have is, where did you get the meaning of the case that you are now reciting to me? And my guess is that you get it from the meaning that the case has come to have in our culture. People say that what Brown stands for is the idea that separate but equal is unconstitutional. And people tell me that it overruled Plessy against Ferguson. Homer Plessy's birthday was yesterday, by the way. The reality is it didn't. Right? Browder against Gale overruled Plessy against Ferguson 2 years after Brown was decided. All Brown decided was that you couldn't segregate black children from white children, right, in the provision of public education. But what it did do is it did set out a marker that suggested that that kind of separation was no longer going to be constitutionally permissible. So even though it addressed one institution, the debate it started is one that suggests that the norm of equality is in fact going to be rooted in our Constitution, and it's going to have a dimension as to the distribution of social goods and how race might figure in the distribution of those social goods. Now, if Brown had solved the interpretive problem for questions of equality, especially as relates to race, I could stop here. But of course, the struggle, that is the struggle outside of the courtroom, continues. So that you could say that Brown stands for the proposition that the state may not subordinate people on the basis of race. And certainly it may not subordinate black people on the basis of race. Or you could say what Brown stands for is that the state may not use racial classifications at all unless it first points to a previous harm. Well, those are radically different propositions. And they're certainly radically different propositions for the purposes of constructing social policy. What I want to suggest to you, if you read the case law up to this moment, is we're still having that debate. Now, Brown did shift the framework within which the debate will be undertaken, but it didn't resolve it. And that's one of the points that I was making earlier, that your engagement in public discourse as lawyers not only permits certain interpretations to become more plausible, but also limits the kinds of interpretations that will be permissible within the range of values that the culture has. So let's go back to the atmosphere. Okay? So, I'm giving you an example now from LGBT issues, giving you an example from race relations, I've given you an example of what it feels like to be losing in the climate debate. But let me tell you about a series of cases that were filed on Mother's Day a year ago, 2 years ago now. One of my mentors, a particularly great man, passed away last week. His name was Joe Sachs. There's no reason many of you would know the name Joe Sachs, but I can tell you that what counts for environmental law would be radically different if Joe Sachs had never lived. And he's the fellow who taught me environmental law. But he did something more important than creating environmental law. What he did is he recovered and rehabilitated a doctrine called the public trust doctrine. Now, what is the public trust doctrine? The public trust doctrine is an ancient doctrine rooted as far back, at least, in our legal tradition in Roman law, but it makes a very simple claim. And I'm going to argue that it makes a claim that goes to the heart of the legitimacy of what government is for. The claim is this, that there are resources that all of us share in common. And the government has an obligation to manage those resources in the interest of the public. Not in the interest of a part of the public, not in the interest of those people who can lobby most effectively. It has an obligation, I would argue, a constitutional obligation to manage those resources consistent with the public good. About, 10 years ago, 15 years ago, I can't remember. When all of y'all were in elementary school, I suspect. I wrote a piece that was not widely appreciated, I guess, called "Who Owns the Sky?" And it asked a simple question. And it asked a simple question about emissions trading programs. Because emissions trading programs were introduced as an environmental reform in order to produce a more efficient management of the reduction of air pollutants. And so I had a simple question. And the question was, if there is profit to be made from the trading of the carbon loading capacity of the atmosphere, who ought to capture that profit? The people who are adding the pollutants to the atmosphere, or the people who have an interest in the resource that's being used? Since it's the atmosphere that's being used, I made a relatively simple claim that every person who breathes has an interest in the atmosphere. So if you don't breathe, then you can count yourself out of that class. But if you do breathe, you have an interest in the management of the atmospheric resource. And if there is value to be extracted from the management of that atmospheric resource, it shouldn't be captured just by those who are contributing to the pollution of that resource. It ought to be captured by those of us who are sacrificing some of our resource for that benefit. And it applies the public trust theory to make that argument. And I don't mean capture it for the government. I don't mean capture it like a tax. I mean literally capture it for each of you. Capture it for each of you so that the value might be invested in, say, something that a friend of mine called individual trust accounts. So that the value that's produced by the reduction of carbon loading capacity of the atmosphere, the value that's extracted for that, ought to flow to each of you so that you have something to hold on to when the government is trading away an interest that you have. And the government has an obligation to you that comes from what I would argue is the constitutional tradition. Now, what is the Constitution? The Constitution is the written document that both outlines the procedures of government and the normative structure within which those procedures will be elaborated. But people point to our constitutional tradition as being critically important because it's the tradition of a written constitution. Now, why do you write something down when you're making a contract? Well, you write something down because what you want to do is you want to memorialize the resolution to disputes that you have. You say, this is what we agree to resolve the dispute. The things about which you are silent are things that you agree to and don't need to memorialize because they're agreements that you share, and you share almost like breathing. So the Constitution is written on something, and my argument is that what it's written on is those set of shared values that are so deeply rooted that they don't need to be discussed and memorialized because they are the things about which we are resolving our disputes to push forward. And part of that is this obligation that the government act in the interest of the people. And the legal expression of that is the public trust doctrine when it comes to resources. So a group in Oregon called Our Children's Trust filed a series of lawsuits or administrative actions in all 50 states on Mother's Day. And their argument was pretty simple. Their argument was, we know what the range of acceptable pollution by greenhouse gases is that will mark the tipping point in irreversible degradation of the atmosphere that will lead to the kind of climate instability that will make life increasingly more difficult and will use up the resources that belong to us. The government has an obligation to act to make sure we don't reach that tipping point. And so they filed suit. Now it's a strange kind of suit, right? Because you probably don't know all of it yet, but you're learning, right? You say, well, wait a minute, where's the standing? Don't we have a separation of powers problem? Don't we have justiciability problems? Don't we have, I can go down the list of potential problems that you might have with litigation. But this is when you can recur to Professor Sachs. Because what Professor Sachs said is, in the public trust context, the courts cannot tell legislatures what to do, but they can tell legislatures that they have to do something. And what he termed it was legislative remand. It's a remedy you don't hear often, but it's a way to put something on the legislative agenda that might otherwise not get there. So the argument is the government has to do something. We're not saying what specifically, and in each jurisdiction may be different. But they've got to do something to prevent the tipping point from being reached. Well, what does that have to do with durable legal change? I hope I gave you some clue as to why I think it has something to do with what I call our constitutional tradition. But let's go back to Professor Stoddard. What Professor Stoddard said was, look, that 15 years of struggle, those 15 years of struggle that me and my friends had in New York City to change the rules felt like losing. But when we finally changed the rules, what we realized we'd done is we'd changed the ground within which those rules would be rooted. So this public trust litigation, the public trust idea, is scoffed at. Legal experts far more acute than I have dismissed it. But my argument is that the debate about what government is for is part of our constitutional tradition. And the resource dimension of that is part of that discussion too. And what the public trust discussion and the climate instability discussion is about is whether government ought to feel itself completely free to act in ways, or to act in disregard of the obligations that it has for us. And we need to have that discussion. In fact, that discussion is happening now. It's happening across the country. It's happening in ways not necessarily in the Congress, right? But it's happening in cities. It's happening in states. Robinson Township in Pennsylvania. I'm sure you all read that case, just came down a couple of weeks ago. I'm sure you haven't, actually. What did Robinson Township, the court in the Robinson Township case say? What it said was the state law doesn't overrule a local ordinance. This was in a case involving fracking. Doesn't overrule a local ordinance where the state law failed to take into account what are essentially the public trust duties that the state has to regulate the conduct of gas extraction through hydraulic fracturing. Well, that was, in fact, a relatively radical idea, because one of the claims against the application of the public trust doctrine is, wait, we don't have to worry about that because statutes have displaced the public trust duty. And what the court in Pennsylvania said is, not so fast. What we as courts get to do is to really ask, what is the duty and did this statute satisfy it? The court would not have felt that if 20 years earlier, take it back, 30 years earlier, God, maybe even earlier than that. Let's say 35, just to be on the safe side. The people of Pennsylvania hadn't come together not long after Earth Day and said, you know what we need to do? We need to put the right to a clean environment in our Constitution, because there seems to be some disagreement about whether that duty is incumbent upon the state to recognize. And so they, like many states, passed an environmental rights amendment. And what the court in Pennsylvania said is, you know what? They didn't do that for their health. They didn't do that because they like to use ink. They didn't do that because they wanted to feel good just about for passing another amendment. They did that because it reflects what the legislature ought to be legislating for in the context of resources. That kind of commitment, that kind of debate, right, which was triggered in 1971 when the first Earth Day took place. I should tell you now, Earth Day is now the largest non-religious holiday in the world. And it's celebrated by more people across the globe than any other non-religious holiday. But it's the debate that started in Earth Day, started by lawyers, that has generated and finally come to fruition, at least at one judicial level, in the decision in Robinson Township, and in the decision in, of all places, Texas, which held that, in fact, there is a public trust duty to protect the atmosphere. It's being appealed, I can tell you. And that the legislature needs to act. But all of those debates were initiated by activist lawyers, conscious of their roles, conscious of both being technically good lawyers and conscious of the values that animated their entry into the profession. All of those elements are necessary to produce durable legal change consistent with our constitutional tradition. And I think, if I can close now, is I'd like you to think about what you're doing. most of you are going to do private practice, and I'm not suggesting that public interest or government work is where the action is, because that's not what most lawyers do. Most lawyers solve problems daily for ordinary people or for businesses. But it's in the daily resolution of those problems and helping people think through about how those problems ought to be resolved where you exercise the public as well as the private function of the profession that you're undertaking to join. And so the idea that animated your entry into law school, whatever commitment to your sense of the right, the good, and the just might have been, will continue to animate your actions as lawyers. And never for a minute doubt that what feels like just one small step is important, especially if it's linked with others who are also making steps to produce the kind of change that you think is necessary. Thank you. And I'd be happy to answer any questions about what I've just said, or why the Dodgers are going to win the National League this year. I grew up outside of LA, so I have to confess I'm still loyal to the Dodgers. I know that that puts me in bad company sometimes. Any questions?
Hi, yes, I was just wondering if you could perhaps elaborate a bit more about the idea of public trust and how logistically that would work, because I find the idea pretty fascinating. Thank you.
But the way Professor Sachs, when he articulated the remedies that would flow from it, he was largely looking at administrative procedure. And he was looking at whether administrative agencies had obligations that were implicit in their charge. He also, as I said, produced what he called a legislative remand. So basically what the court would say that that this particular regulation is deficient because it fails to take into account or to demonstrate how it satisfies the public trust obligations. And the public trust obligation can be thought of this way. You all know what a takings is, right? That is, the government can't take private property and put it to public use without just compensation. Well, if you imagine the reverse of that the government can't take public property and put it to private use without the public being compensated in some way. And the compensation isn't necessarily monetary, right? It's compensated by a continued service that those resources were making for the people. So if you think of it as kind of the opposite of the takings clause, that's the way you think about it conceptually. And if you were a court, you would say, look, what the demonstration that the legislature or the administrative agency has to make has been insufficient, so we're going to send it back down. It may result only in more procedure, but what it also may result in is the people who are contesting the particular action being able to articulate exactly what that remedy ought to look like. And that, of course, is a political question, right? And so law always treads a line between moderating the kind of the private goals, right, and public goals. And that's kind of where the public trust doctrine sits. Okay. More questions? I'd be happy just to talk about how I got to do what I got to do, but.
I was just wondering what your thoughts are on the recent ban on bottled water in San Francisco.
It's not a ban on bottled water, right? It's a ban on plastic bottles, right? And so I suspect, you know, to the extent that I don't know much about it except that they have banned it. It's like banning plastic bags, right? I suspect it's a way to limit the wasteful use of a particular resource, the plastic, right? Especially if it's not easily recycled. And it is, but perhaps not as effectively as it has been. And so it's, you know, my view is that San Francisco can do it. I mean, it's not, there's no, there are certainly alternatives to plastic bottles, right? So I think it's probably a step in the right direction. When I said that things are happening at state and local level, environmentally important things are happening at state and local level, I meant it, right? Because one of the things to use your question as a way to talk about that a little bit, right, is California enacted what's called AB 32, which is an emissions trading program. It's a one might argue the largest climate change initiative that this country has undertaken. There's also the Cool Cities program. So many cities have undertaken to reduce, to the extent that they have things within their jurisdiction, to reduce greenhouse gases and their contribution to greenhouse gases by changing both uses, resources that they have to purchase, right? But land use programs, transit priorities. Right? The Cool Cities program covers about 80 million people in the United States. So when you hear the idea that Americans aren't committed to acting to address climate instability, well, that's just not right, right? Because you have 30 million people in California who've made the commitment under AB 32 to address it. You've got 80 million people in the cities that have joined with the Cool Cities program, right? So right there, and some of those in California, there's overlap, right? But you have close to 100 million people, right? 100 million Americans, right? Who have undertaken some activity to address climate instability, even when the Congress dithers and likes to pretend that it is a question that is still subject to scientific dispute, right? At some point, the federal legislature that we have will respond if the people require it to respond. I'm not saying it's an easy fight, but remember, right, it took 100 years between the end of slavery and Brown against Board of Education to suggest that the treatment of African Americans in the way they had been historically treated was legitimate. The thing that's one of the things that's amazing is how quickly some changes can take root. Right. So my view is that we should be hopeful rather than despairing, because there's the local level, and you shouldn't. Lots of things can happen at the local level, regional level. And counties actually are really important, regional level and state level, that can produce change. So the ban on plastic bottles in San Francisco is one small effort in that larger mosaic. The learned hand actually had this metaphor which I loved, and I'm going to mangle it. I apologize, right? But the creation of law, he said, and I think it's the creation of a law that is related to social change, is in the same way. The creation of law, he said, is like a coral reef. Viewed from afar, a coral reef is beautiful, right? But each coral that contributes to that coral reef is unconscious of the total shape of the reef as it leaves its skeleton, right, to produce this thing that we admire and enjoy. And laws like that, when I think of all the cases that I've been involved in, who knows exactly? I didn't know in advance exactly how they're going to fit in, right? But I knew that the action would contribute at least partially to the change I wanted to see happen. So the bottled water ban, it's like, imagine that as one little coral animal leaving its skeleton on this reef that maybe will produce climate change action in this country. Yeah. Yes, sir.
Hi. Do you think that, we talked about local change and regional change. Do you think local, regional, state change will long-term be enough to protect against and prepare for, as you mentioned, the climate instability and climate change without federal level action and congressional kind of action on it? Because they've been talking about it for a long time. And as you mentioned, a lot of critics think it's not even happening. So do you think it's possible for that change to last and be realistic to protect people and our future against it without federal action?
The answer is no, of course not, right? But what I'm arguing is that it is and may well be a necessary precursor to the federal action, just like national action is necessarily a precursor to international change, right? So that the idea of what counts as a human right, to shift categories altogether, right, didn't arise as an international norm until the debate at the national levels had taken some root. And it continues there is a continual struggle. So there are levels, and change at each level is important. Ultimately, in a federated culture, legal culture like ours, what you want to have is change at the federal level. But, that's right now that's just one fight among many. Now, you look at the effort to pass a climate change bill, right? The Waxman-Markey bill. The Green Group spent $350 million, and ended up with nothing, right? And so you can analyze that in many ways. You can say, look, $350 million is a lot to spend to try to get a bill changed, but it's really nothing compared to what the opponents spent. But you could also look at it a different way. You could say, the one thing politicians can do, right, is count. The one thing that politicians want to do is to be reelected. And so should the money have been spent playing an inside the Beltway game, or should it have been spent organizing and mobilizing in important races around the country? To say, look, you may not really care about this issue, but you do care about being reelected. And you're not going to be reelected if you vote wrong on this issue. Right? Who knows? Theta Skocpol at Harvard did a study on the failure of the green groups to secure the climate change legislation. What I want to tell you is operating at the local, regional, and state level are important elements to producing the kind of change we want to see at the federal level. And part of it is by having the debate that helps mobilize people to produce that change.
We're out of time.
Oh, thank you. Okay, thank you. And welcome to the profession.